I'm back at the Colorado Supreme Court. Today is Tuesday, September 23rd, 2025, and I am here today for Sheriff Justin Smith. As with John Fayen's lawsuit a couple weeks ago, I'll post the entire petition for writ to the Colorado Supreme Court along with this video so that you can read the petition in its entirety. The basic idea in the petition for writ in the Sheriff Justin Smith case is that the Colorado Court of Appeals pretended not to understand what I was saying in my appeal. That's laughable, and as with the John Fayen case, it's very clear what I am appealing and what has gone wrong in the Sheriff Justin Smith case and the Sheriff John Fayen cases. But there is a significant update in the Sheriff Justin Smith lawsuit in that the Colorado Supreme Court Office of Attorney Regulation Counsel, which is ironically upstairs above where I'm standing, is still investigating Justin Smith's defense attorney, Brian Reynolds. In late September, I was interviewed again by the trial division of the Colorado Supreme Court Office of Attorney Regulation Counsel, specifically regarding Attorney Brian Reynolds' actions in the Justin Smith lawsuit. A few days after I was interviewed by the Office of Attorney Regulation Counsel, Brian Reynolds was interviewed as well, and we expect a decision to be made in the investigation of Brian Reynolds' unethical and illegal actions to be final in October. I'm going to read a small piece of the petition for writ that was filed a few moments ago, just so that you can understand how important this petition for writ is to everyone in the state of Colorado. So this next paragraph I'll read to you is taken directly from 8th Judicial District Court Judge Stephen Jouard's order on my motion for sanctions. Judge Jouard says, based upon a review of referenced depositions, the court has real concerns as to whether defense counsel Reynolds' conduct in defending and taking depositions in this matter violated the rules of professional conduct. As noted in plaintiff's motion, defense counsel asserted objections 373 times during plaintiff's deposition of defendant Justin Smith. A review of the transcript reveals that many of the objections asserted also directed the deponent, that's Sheriff Justin Smith, not to respond to the question posed. Many of the objections and directions not to answer do not appear to be supported by any rule or case law. Accordingly, the court has serious concerns as to whether defense counsel Reynolds acted properly and complied with the rules of professional conduct. Given these concerns, the court will refer this matter to the Office of Attorney Regulation Counsel for investigation. So that was months and months ago. The Colorado Supreme Court Office of Attorney Regulation Counsel has been investigating all these months, and we are getting closer to a decision. During Justin Smith's deposition that was held in Grand Junction, Colorado in February, what happened was Justin Smith's defense attorney objected 373 times, at least 373 times in 6 hours. That means that Brian Reynolds objected one time every minute for 6 hours. And if you're an attorney or you're familiar with how depositions work in the state of Colorado, that's an absurdly insane amount of objections. And as the district court judge noted in his order, most of those objections were not based on any rule or any case law.
Yes, I saw the heading on each page.
And what is this?
Appears to be a supervisory inquiry.
Who is the supervisor conducting this inquiry?
It states Robert Coleman.
And what date was this inquiry completed?
The objection to document speaks for itself.
Can you see a date right underneath Robert Coleman's name?
I do.
What is that date?
Is that different than your previous question of what date it was completed?
I just asked you the question, what date is below Robert Coleman's name?
Do you want to direct him to anywhere in particular, because there are multiple dates?
He's on page 1, looking at page 1.
If you're directing him to something in the document, I'm going to tell him not to answer. The document speaks for itself. You do not need to just recite what the exhibit says for Ms. Lynn's pleasure.
Yeah, I'm looking at what's on your Exhibit 10.
You just testified that you can see Robert Coleman's name on page 1, and I asked you, what is the date underneath his name?
You don't need to.
This is for the record.
You don't need to recite what this document says. This is getting fun. The gamesmanship by Ms. Lynn.
These are normal questions that are asked of deponents all the time.
You're not required to read into the record a document that is part of the record.
So when you file a petition for writ at the Colorado Supreme Court, you actually have to tell them why this matters, not just to your case as an individual, but to everybody in the state of Colorado. And the reason this case matters to everyone in the state is that if the Supreme Court rules that it is legal and ethical for a defense attorney to destroy direct evidence of his client's guilt, then everybody in the state needs to understand that that is how the state of Colorado operates. That to win a case, you're allowed to destroy direct evidence of your client's guilt. That's why this matters. If the justices at the Colorado Supreme Court rule that it is legal and ethical for defense attorneys to destroy direct evidence of their client's guilt, then you can imagine what's about to happen in many, many cases. If you are a desperate attorney and all you care about is winning, then a lot of evidence of client's guilt is going to go missing. But let's bring it back to Sheriff Justin Smith. The record is clear, the official record, law enforcement records, many, many court records is clear that Sheriff Justin Smith broke the law in 2011. He continued to break the law until the end of 2019 by hiding the records of John Fayen's guilt and his own guilt, along with other law enforcement officers at the Larimer County Sheriff's Office in Fort Collins, Colorado. All of that is clear, it's on the record. There's no disputing the crimes that Sheriff Justin Smith and Sheriff John Fayen committed against me when they attached a GPS tracking device to my SUV without a warrant, never tried to get a warrant, and then left that tracking device on my SUV for at least 4 months. There's no disputing that. Nobody's ever denied that that happened. Between 2011 and the end of 2019, Smith and Fayen and Larimer County Attorney David Arode actually hid those records. They said they didn't exist. When an attorney breaks the law to win his client's case, from that moment on, there's not a single ruling or a single opinion by any court at any level that makes any sense until that bad act has been remedied, so that the plaintiff in the case has a fair and just process that she can apply to her own case. That's why I'm here again at the Colorado Supreme Court. We're waiting for a ruling from the Colorado Supreme Court Office of Attorney Regulation Counsel on Attorney Brian Reynolds, and now we're going to wait for opinions by the Colorado Supreme Court on whether or not they are going to give their blessing to attorneys who destroy direct evidence of their client's guilt.